Uh, Good evening, friends. Once again, welcome to each one of you in this CASA platform to discuss the challenges, the verdict pronounced by the Supreme Court yesterday. We have with us our eminent expert speaker, CA Advocate Divyanshu ji. Divyanshu ji, welcome to you.
Thank you so much. Thank you so much, Sumit ji.
Our experts from Team CASA, CA Sachin Sinha ji, CA C.M Jain ji, welcome to you on this channel.
Thank you, sir.
And definitely we will discuss various aspects which we are not covered in the messages, क्योंकि कहीं ना कहीं जो मैसेज सर्कुलेट हो रहे हैं, हम लोगों ने बहुत सारे ऐसे मैसेज स्टडी किए होंगे जहां पर कुछ पॉइंट्स फेवरेबल टू डिपार्टमेंट हैं, फेवरेबल टू एसएससी. उन सभी इश्यूज को आज हम डिस्कस करेंगे. अगले 1.5 आवर जितना भी टाइम लगेगा, हमारी कोशिश है कि सारे इश्यूज को डिस्कस किया जाए और उन्हें समझा जाए कि इस वर्डिक्ट से क्या क्लाइंट पर इम्पैक्ट आने वाला है, क्या प्रोफेशनल्स को करना है. इन सब इश्यूज को टच करेंगे. वंस अगेन वेलकम टू ईच व्यूअर्स, CA advocate and other professional colleagues from the entire, not only from the region, from the country. I can see the various faces from Punjab, Haryana as well as UP. So once again, welcome to each one of you. Before starting, I request Sachin ji to give brief of the topic.
Good evening, friends, and thank you so much, Sumit ji, for organizing such a event, such a important topic for the purpose of discussion, and invited Divyanshu sir, who is the person who has authority on this topic. And I think more than 500 cases have been filed by Divyanshu sir, and almost out of 9 court which the Supreme Court has already mentioned in the judgment, 4 or 5 court has been dealt by Divyanshu sir. So, sir, as we discussed in the beginning, while we are discussing about the 148 the capital nuances and one interplay of old 148 and the new 148 capital A, and that time it was understanding that okay, whatever the notice has been issued, it was all incorrect, and that's why we started filing writ before the Honorable High Court. And based on this judgment, almost all the judgments were in the favor of SSC. So after this, the department thought, okay, it's a big loss for the revenue, because if this continues, almost 90,000 matter is in line for the purpose of notice, and out of 9,000 were already in the respective court. So if this were continue, then the revenue has a great loss in this regard. But if what I have understood from the judgment which yesterday come, and after this, Solicitor General N. Venkataraman has given a note to the tax sutra, and the very important line which sir has mentioned in his note, that this judgment is a blend of exercise of constitutional power, judicial discretion, besides using the legal pair of scissors in isolating the default and defaulters, and applying the doctrine of the complete justice by proceeding to regularize an action which was declared to be default through judicial interpretation. So, sir, if you when you go through the judgment, the Honorable High Court has also mentioned that this is a mistake from the department while issuing the notice. So whether court is, I'm not going to challenge 142 at this moment, but I just wanted to input from your side that whether the court is right by allowing which is incorrect in view of court. Just can I say that it is a benefit or doubt, or it is benefit given to the department without any doubt? So this is what I understood from this judgment. Of course, we will discuss in detail from Divyanshu sir. So back to Sumit ji.
Thank you, Sachin ji, for wonderful insight and throwing the some questions which need to be answered by CA Advocate Divyanshu ji. My other colleagues from the team, C.M Jain and Asa Sharma ji, will take up all the queries in this regard from the participant. Whosoever have any query, you can post in the chat box. Now, I straight away invite our good friend and advocate CA Divyanshu Agarwal ji, who has delivered and participate in this judgment, participate in the process of this case study. So straight away request Divyanshu ji to deliver. Over to you, Divyanshu ji.
Thank you so much, Sumit bhai. Am I audible, Sumit bhai?
Yes, perfect, perfect.
Yeah.
Sir.
I'm extremely sorry. I believe some problem is coming. My video is not coming. It's showing it completely blank.
No issue, sir.
Okay. Thank you so much, Sumit bhai. Thank you so much, Sachin bhai. Thank you, all of you, for giving me another chance to come and discuss in detail about what the Honorable Supreme Court has given in this verdict. This is a very important judgment by Honorable Supreme Court. As per my understanding, I believe in history of last 72 years, this is the first judgment wherein the Article 142 was invoked by Honorable Supreme Court in the revenue matter, especially in income tax jurisprudence. Let us first quickly short and discuss what is the background of the issue. As everybody is aware, what happened during this COVID. So during that process, not only the assessee, but also the department was facing a lot of problem. So the government come out with a TOLO, which is an ordinance effective 31st March 2020. And they have extended the due dates and the deadlines. Simultaneously, the situation was not improved 2 years back. So finally, in September 2020, they have introduced a relaxation act, which we call TOLA. And they're given a power, the central government is given a power to the CBDT to issue notification based on the TOLA. So notification was issued. In between the process, the budget 2021 is into the process. Honorable Finance Minister has given a budget speech wherein the major changes was done on the reassessment part. And the provision is going to be effective. The new provision is going to be effective from 1st April 2021. TOLA was simultaneously going through. The notification was issued for extension. And on 28th of March 2021, the Honorable President of India has given an assent to the bill and it become an act. And the judgment and all the provisions of the reassessment scheme is effective from 1st April 2021, the new provisions. Now, what happened? During this period, there was a notification issued. Notification was issued by the CBDT, Central Board of Direct Taxes, wherein an explanation was inserted, which talks about that they gives a power to the assessing officer to take the benefit of the old law and can issue a notice. So AO was actually relying on that explanation to the notification and they have started issuing the notices. Usually these notices were issued between 1st April 2021 till 30th June 2021 because based on two notifications, the date was extended till 30th June 2021. So as everybody was aware, assessment year 2021, assessment year 13-14 was going to be time barred under the old law by 31st March 2020. But because of TOLA, it was extended till 30th June 2021. And assessment year 14-15 was going to be time barred on 31st March 2021. But because of Relaxation Act was extended till 30th June 2021. But the catch comes here. If the new provision, the procedure has been prescribed effective 1st April 2021, department was supposed to actually issue notices under the new procedures instead of the old procedure. But the department pleading was that they are relying on the notification explanation to that two notification, which gives them power. So the litigation started. This matter travels before Honorable Chhattisgarh High Court, learned single judge. They have dismissed the writ and have given the findings that the department has done correctly. So the matter then travels in between the process, Honorable Bombay High Court in the matter of Tata Communication, wherein the 148A pre-notice process was challenged before Honorable Bombay High Court. And simultaneously, the explanation to that two notification was challenged. So how can, that's the question which was raised. How can, this is ultra virus, how can they overreach the legislature, which was already passed by the parliament? The notice was issued, stay was granted in Honorable Bombay High Court. Simultaneously, the matter travels to different high courts, which in the case of Delhi High Court, Manmohan Kohli, Mudra Finance, simultaneously in other high courts. As friends, you have already gone through the Supreme Court judgment. Only some of the judgments details were there in the tabula format in which the judgment was already pronounced. I'll give a background. In Honorable Punjab and Haryana High Court, the matter in the month of February 2022 was adjourned sine die by the Honorable Punjab Haryana High Court, and they wanted to wait for the outcome of the matter pending before Honorable Supreme Court in the case of Ashish Agarwal. Simultaneously, in other high courts also, they have not. Honorable Gujarat High Court have reserved. Fortunately, I being also part of that Honorable Gujarat High Court proceeding. So Honorable Gujarat High Court has reserved the judgment on 21st of January 2022, but they have not pronounced till date as per my knowledge. In the same way, many other high courts wherein the judgment is pending. Lucknow bench of Allahabad High Court, the judgment is pending. So certain things which we need to see. Three aspects is coming. One, wherein the High Court has pronounced the judgment. Two, wherein the matter is pending before different high courts. And three, wherein the SSC has never ever challenged that notices before the different high courts. They were not into the rate. So we have to divide it into three categories. Now what happened? Based on these outcomes, around 90,000 reassessment notices was issued. These data is coming from the Honorable Supreme Court judgment given by the Honorable Learned Additional Solicitor General before Honorable Supreme Court. And around 9,000 notices were challenged before different high courts and a writ petition. So now, before coming and seeing what is the future way forward in the matter, it is equally important to see what is the relevant paras, what was the relevant part, what was the contention taken by the revenue before the Honorable Supreme Court, what was the observation of the Honorable Supreme Court, what was the key areas wherein the Honorable Supreme Court has analyzed before invoking Article 142, and what was the verdict given by Honorable Supreme Court. Let us first see the judgment to understand it properly before coming to the final course of action, what we understand based on this judgment. So I'm sharing a screen. I have prepared a presentation.
So please make it full screen, sir. Presentation mode.
Is it now visible?
Yes.
Yes, sir.
Yes.
Perfect. So this is the first name is Union of India and others versus Ashish Agarwal. This matter travels from Honorable Allahabad High Court. This was not the lead matter before Honorable Allahabad High Court. Lead matter was writ tax number 524/2021 in the case of Ashok Kumar Agarwal. But the department has not filed SLP in that Ashok Kumar Agarwal. They have filed it before Ashish Agarwal, which is part of that 74 matter batch. The leave was granted. That is the reason this was converted into a civil appeal number. The civil appeal number is 3005/2022. The judgment was pronounced on 4th May 2022. Now, para 2.1 of the order says, this judgment is applicable on all the judgments and orders passed by various high courts on the similar issue. So automatically, though the SLP was filed against Honorable Allahabad High Court, other high court, the SLP has not been filed, but the Honorable Court has given a finding that this judgment is going to impact Pan-India and this is going to cover all the high courts on the similar issue. There was a tabular format prepared by the Honorable Supreme Court on page number 5 and 6 of its order. So page number, I'm talking about the font size of the order which we have downloaded from Honorable Supreme Court website. They have covered Honorable Allahabad High Court judgment, Honorable Rajasthan High Court Learned Single Judge judgment, Honorable Delhi High Court judgment, Honorable Calcutta High Court 2 judgment, original and appellate jurisdiction, single bench, single judge, learned single judge judgment, Honorable Rajasthan High Court division bench, which confirmed learned single judge judgment, Honorable Madras High Court judgment, and Honorable Bombay High Court. The last one was Honorable Bombay High Court pronounced on 29 March 2022. At that time, this SLP was pending before Honorable Supreme Court. So this is given in para 2.1 of the order. Now, in this case, the Honorable Supreme Court has actually analyzed the reassessment law, which was pre-Finance Act 2021. As everybody was aware, the law was changed in 2001. Via Finance Act 2001, certain law was changed of the reassessment law. Then some changes was done in the law in by Finance Act 2012. So the Honorable Supreme Court has analyzed the law prior to Finance Act 2021. The analysis part is on para 3 of the order. I'm not going into that. They have gone through section 147 under the old law. They have gone through section 148 under the old law. They have gone through section 149 under the old law, as well as section 151 under the old law. After analyzing the pre-Finance Act 2021 reassessment law, the Honorable Supreme Court has analyzed section 3 of the Relaxation Act 2020 and the notification which was issued under the power given by the Relaxation Act. They have analyzed those things. which is given in para 3.1 of the order. And they have actually analyzed the explanation, which was also the challenge point before different high courts, of the notification dated 31st March 2021 and 27th April 2021. After analyzing both these things, the Honorable Supreme Court has analyzed substituted sections of 147 to 149 and section 151. This is applicable with effect from 1st April 2021 after getting an assent from the Honorable Finance Minister on the bill on 28th March 2021. The detailed extract was there in para 3.2 of the order. I'm not going into that. They have seen new section 147, new section 148, new section 148A, the newly inserted section 149, the time limit, and section 151, sanction for issue of notice. These things the Honorable Supreme Court has analyzed in para 3.2 of the order. So they have seen pre-amendment, pre-Finance Act 2021 law, they have seen the Relaxation Act, they have seen the notification, they have seen the new law. After going through that, they have analyzed that this was the contention. So friends, this is very important, everybody, to know what was the contention of the revenue before the Honorable Supreme Court. That was a catchy. Why? What was the reason behind Honorable Supreme Court invoking Article 142 of the Constitution? This is at para 4. I am taking the relevant part. Despite contention of the revenue, this is important. Despite the substituted section 147 to 151 of the Income Tax Act by the Finance Act 2021 coming into force on 1st April 2021, the revenue issued approximately, friends, this is important, the revenue issued approximately 90,000 reassessment notices. These were the notices issued pan-India effective 1st April 2020, majorly was between 1st April 2021 till 30th June 2021 to the respective SSCs under the erstwhile section 148 to 151 thereof. And the reason was these officers were actually relying on the explanation, the notification, which was dated 31st March 2021 and 27th April. So this notification of 31st March came into picture. And based on that, they have started issuing the notices. Obviously, as the departmental officers, they're supposed to rely on the notification which was issued by CBDT. Now, another pleading with the contention which they have taken was the said reassessment notices were the subject matter of writ petition before the various high courts. The respective high courts have held that all the respective reassessment notices issued under the erstwhile section 148 to 151 of the Act are bad in law, as the reassessment notices issued after 1st April 2021 are governed by the substituted section 147 to 151 of the Act, substituted by Finance Act. Consequently, the respective high courts have set aside all the reassessment notices issued under section 148 of the Income Tax Act wherever assailed. Important point, highlighted, underlined, italics. The common judgment and order passed by the High Court of Allahabad is the subject matter of the present appeal. So the revenue has put forward before Honorable Supreme Court was, we are here against the Honorable Allahabad High Court judgment. However, now another point. However, the High Court of Delhi, in its common judgment and order dated 15th December 2021, while quashing the respective reassessment notices, has also observed that if the law permits, this is in red, important point, the revenue to take further steps in the matter, they shall be at liberty to do so. So other than High Court, they have mentioned this thing before the court, that the Honorable Delhi High Court has also, in a common judgment, has quashed the respective reassessment notices on the same issues. And they have given also a liberty to the revenue to take further steps in the matter. After this contention, now, they have heard the argument which is at para number 5. The detailed contention was not recorded in the judgment of the assessee sides from the side of the respondent. But now, this was the Honorable Supreme Court observation. These were the observation after hearing the argument. What was the pre-Finance Act 2021 litigation ground? Usually on what ground? Usually during early regime, on what ground usually we challenge reassessment notices? This is given in para 6 and 6.3 of the order. These were the grounds which you usually take in the earlier regime. No valid reason to believe. These were the findings recorded in the Honorable Supreme Court judgment. No tangible, reliable material, information in possession of the assessing officer, leading to formation of belief that income has escaped assessment. Third ground, no inquiry being conducted by the AO prior to the issuance of notice. Fourth ground, reopening is based on change of opinion of the AO. And one of the major grounds which we usually take in the earlier law was, lastly, the mandatory procedure laid down by this code in the case of GK and Drive Shop India Limited versus Income Tax Officer has not been followed. The Honorable Supreme Court has analyzed these were the grounds which the petitioner or the assessee usually take under the earlier regime. But prior to Pre-Finance Act 2021, while reopening an assessment, the procedure of giving the reasons for reopening and an opportunity to the assessee and the decision of the, basically what they are trying to say is the reason to believe copy, opportunity for filing the objection as well as the objection disposal were required to be followed as per the judgment of this court. These were the grounds on which usually we were going to file a writ before Honorable Supreme Court, before Honorable High Courts, Jurisdictional High Court. These were the grounds which we take in the earlier regime, Pre-Finance Act 2021, following GK Drive Shop. So at that stage of objection disposal, you usually go and move a writ before Honorable Jurisdictional High Court by saying that these were the things which is missing, which was given by the guidelines as per the Honorable Supreme Court judgment. They have analyzed this thing. Now, Honorable Supreme Court observation after Finance Act 2021 comes into play is coming at para number 6.4 of the order. Very important to read line by line of the judgment before coming to the conclusion what was the intention of the Supreme Court and what is the future course of action we need to do. Para 6.4 of the order. However, by way of section 148A, this was the newly section. The procedure has now been streamlined and simplified. It provides that before issuing any notice under section 148, the assessing officer shall, 1, conduct any inquiry if required. If required is important. Reason was if required is also highlighted in bold in the judgment. If required means the Honorable Supreme Court has mentioned in one of the para that it is not mandatory for the AO to conduct an inquiry. So this is very important. I'll come to that para also. So one of the reasons the lot of confusion comes if required. They have highlighted in bold if required and they have given and para number 10 that this is not mandatory to conduct before conducting any inquiry. They are supposed to take in approval of specified authority. So we need to be very sure. This is also one of the grounds which the department can take in future. With respect to the information which suggests that the income chargeable to tax has escaped assessment, provide an opportunity of being heard to the assessee with a prior approval of specified authority. Consider the reply of the assessee furnished, if any, in response to the show cause notice referred to in clause B. So 148 capital A clause B is someone we are supposed to file a reply and they are supposed to consider our reply. Now decide on the basis of material available on record, including reply of the assessee as to whether or not it is a fit case to issue a notice under section 148 of the Income Tax Act. And the AO is required to pass a specific order within the time stipulated. These were the understanding, the observations of the Honorable Supreme Court of the law of reassessment post Finance Act 2021. Now let us see what does para 6.5 of the order says. The Honorable Supreme Court observation is, therefore, all safeguards are provided before notice under section 148 of the Income Tax Act is issued. So prior to issue of notice, a lot of conditions there. So all the safeguards are there in advance before issue of notice. At every stage, the prior approval of specified authority is required. So what the observation is, there is a lot of checks and balances in the section. For every stage, the AO doesn't have a discretionary power. They need to take a prior approval of the specified authority. And in fact, under the new law, the specified authority has also been revised. Under the old law, within 4 years, the JCIT was there. This time it is PCIT. Under the old laws, after 4 years, PCIT was there. This time it is PCCIT. So they have increased this, the superior authority stature also, the level also in the new law. Only in cases where the AO is of the opinion that before any notice is issued under section 148 capital A clause B, an opportunity is to be given to the assessee, there is a requirement of conducting any inquiry. The assessing officer may do so and conduct any inquiry. So before giving any opportunity, they are supposed to conduct an inquiry. Thus, if the AO is of the opinion that any inquiry is required, the AO can do so, however, with a prior approval of the specified authority with respect to the information which suggests that the income chargeable to tax has escaped assessment. These are the observations on the new provision, new law of reassessment by Honorable Supreme Court. Now, in para 7, the Honorable Supreme Court has observed, thus, I'm reading very slowly, thus the new provision substituted by the Finance Act 2021 being remedial and benevolent in nature and substituted with a specific aim and object to protect the rights and interests of the assessee, as well as the same being in public interest. They have confirmed what was the finding of the Honorable High Courts, different High Courts. The respective High Courts have rightly held that the benefit of new provision, friends, this is important, have rightly held that the benefit of new provision shall be made available even in respect of the proceedings relating to past assessment years, provided section 148 notice has been issued on or after 1st April 2021. What they mean to say, 113, 14, 14, 15, 15, 16 assessment year, they can issue, subject to the condition the notices is issued effective 1st April 2021 and onwards, because the procedure has to be followed prospectively, not retrospectively. So the AO is, they can issue a notice, open a previous assessment year cases, but follow the procedure prescribed under the law once Finance Act 2021 has been enacted. So Honorable Supreme Court has given the confirmation on this observation, Honorable different High Courts. Para 8, crucial observation. These earlier was observation, these are crucial observations. However, at the same time, the judgment of the several High Courts would result in no reassessment proceeding at all. Obviously, the notices was quashed, the writ was allowed, even if the same are permissible under the Finance Act 2021 and as per substituted section 147 to 151. So what they have observed that now they can, the department, after the judgment, the department cannot continue with the proceeding, though under the new amended law, yes, they can, not under the old law, but now after the Honorable different High Court judgment, they cannot. The revenue cannot be made. Now, friends, this is important. This line is important to understand the thought. The revenue cannot be made remediless, and the object and purpose of reassessment proceedings cannot be frustrated. I'm again repeating this line. The revenue cannot be made remediless, and the object and purpose of reassessment proceedings cannot be frustrated. It is true that due to a bona fide mistake and in view of subsequent extension of time wide various notifications, the revenue issued the impugned notices under section 148 after the amendment was enforced with effect from 1st April 21 under the unamended section 148. Please again see the starting line. It is true that due to bona fide mistake. So they know that this is a mistake by the revenue officers, but they have followed the explanation to that notification. Now this is bold, underlined, highlighted in red. In our view, this is Honorable Supreme Court view, the same ought not to have been issued under the unamended act and ought to have been issued under the substituted provisions of section 147 to 151 of the act as per the Finance Act 2021. On the similar line, on this line, the Honorable Supreme Court is confirming what the Honorable High Court has taken the position. There appears to be a genuine non-application of the amendment, as the officers of the revenue may have been under a bona fide belief the amendment may not yet have been given. Obviously, this is the reason because of those two explanations given in the two notifications. That is one of the reasons. However, para 8 is very crucial observation of Honorable Supreme Court. However, at the same time, the judgments of the several High Courts would result in no reassessment proceedings at all, even if the same are permissible under the Finance Act 21 and as per the substituted section 147 to 151 of that. Obviously, they have a remedy under the Finance Act 2021. They can, but because the explanation varies was challenged, it is accepted by the Honorable High Courts, correct? Obviously, they don't have the power to issue that explanations. The pre-notice process of 148A, which they are supposed to follow before issuing any notice under section 148. And number two, the varies challenge of those two explanations. And the Honorable Supreme Court is accepting also, yeah, this is correct. They are supposed to follow those processes. But the only problem is that 90,000 notices were issued by the revenue officers on following that explanation. 9,000 petition, 9,000 notices were before different high courts. Obviously, there is a huge revenue loss in that situation. In our view, I'm again coming to the fourth point, red. In our view, the same ought not to have been issued under the unamended act and ought to have been issued under the substituted provisions of section 147 to 151 of the act as per the Finance Act 2021. There appears to be a genuine non-application of the amendment, as the officers of the revenue may have been under a bona fide belief that the amendment may not yet have been enforced. Therefore, we are of the opinion, please read this line, friends, this is important. We are of the opinion that some leeway, I'm again repeating, some leeway must be shown in that regard, which the High Court could have done so. Now, what was the direction of the Honorable Supreme Court of the verdict, which is given at page 28 of the order, para number 8, clause 1. Therefore, we propose to modify the judgments and order passed by the respective high courts as under. Number 1, the respective impugned section 148 notice issued to the respective assessee. All the notices issued effective 1st April 2021 and onwards under the old law shall be deemed to have been issued under section 148A of the Income Tax Act, deeming fiction as substituted by the Finance Act 2021 and treated to be show cause notices in terms of section 148A clause B. So they as per the direction, all 148 notices is converted into 148A clause B notices. So every notice issued, now I'm again coming, whether you have challenged in High Court, whether the verdict is pronounced or whether the matter is pending before High Court or you have not challenged in a High Court, all notices issued deemed to be treated as 148A clause B notice. Second point, continuation. The respective assessing officer, friends, this is a future course of action. The respective assessing officer shall within 30 days from today, judgment was pronounced on 4th of May 2022. So 30 days, if you count, it comes to 2nd June 2022. By 2nd June 2022,
Divyanshu ji, your voice is not coming.
Sumit ji, am I audible?
Yes, now.
Yes, sir. Now audible, sir.
Now audible. So on which slide I was not audible?
Yes, sir, this one.
This one?
Yes.
I'm again repeating. So this is very important. The direction. This is a future course of action given by Honorable Supreme Court to both assessee as well as to the department. So the finding was, they have mentioned that we propose to modify the judgments and order passed by the respective High Court as under. I'm reading the clause as well as I'm interpreting also. The respective impugned section 148 notices issued to the respective assessees shall be deemed to have been issued under section 148A of the Income Tax Act. This was the ground which we have taken in different high courts, that they have not complied with the pre-notice process and treated to be show cause notice. So every notices, friends, you have received in your client case effective 1st April 2021 and onwards, wherein they have not complied with the pre-notice process, Supreme Court says you consider it as 148A clause B notice, not 148 notice. Number 2, the direction was given to the revenue to issue within 30 days from today. The judgment was pronounced on 4th May. So timeline was 2nd June 2022, 30 days from today. So by 2nd June 22, all the assessing officer is supposed to provide to the assessee the information and material relied upon by the revenue so that the assessee can reply to the notices within 2 weeks thereafter. Friends, after this pronouncement, the ball is in the court of the revenue. The AO is supposed to give you these details by 2nd June 22. And after that, from the date you have received, you have 2 weeks time thereafter. Counted from the date you have received, you have 2 weeks time to file a reply. So it's a very tight jacket. You need to comply with all the timelines as proposed, as given in the verdict of the Supreme Court. So if you received your judgment details by 2nd June, 2 weeks is, 2nd June is Tuesday, 2 weeks, you count it as 14 days, 8 and 6. By 16th of June, you're supposed to give your objection or the detailed reply. It's a tight jacket. So right now, the ball is in the court of the department, not yours. Once you receive these details, the ball comes to your court and you're supposed to file a reply within 2 weeks. Now question comes, what about inquiry? Court says the requirement of conducting any inquiry with a prior approval of specified authority under section 148A clause A be dispensed with as a one-time measure. Because of Honorable Supreme Court direction, this requirement is dispensed with as a one-time measure. AO is not supposed to now follow this process of inquiry based on Honorable Supreme Court direction. Vis-a-vis, those notices which have been issued under section 148 of the unamended act from, now this is important, 1st April 2021 till date. Why I'm saying till date? All those notices issued in the new law without complying with the pre-notice process of 148A deemed to be treated as 148A clause B as per the direction of Honorable Supreme Court. All notices wherein the revenue is taking the position of pre-Finance Act 2021 regime, they have not issued you 148A, but they have issued you notice under the new regime. These notices were covered under this, including those. Now, friends, this is important. This is interpretation, including those which have been caused by the High Court. Quashing of the writs was an inclusive definition, not exhaustive. So I'm again covering 3 categories comes into this. One, category 1, wherein you have filed a writ petition before Honorable High Court. Honorable High Court has quashed that notice, comes into this. 2, wherein you have challenged, like take an example, matter pending before Honorable Gujarat High Court, stay given, judgment reserved. Lucknow bench, pending. Karnataka High Court, pending. Wherever the matter is pending, this direction comes. And 3, wherein the assessee has not approached, either they have filed the matter but not listed, either they have filed the writ petition but yet not listed, or maybe the writ petition number was not generated, or they have not filed the writ. Everything is come into this as per the direction. So any notices, then in case of the AO is continuing with the proceeding, it is your responsibility to inform the AO and say that, look, this is the Honorable Supreme Court judgment. That 148 notice, go back to 0. This 148 notice is actually deeming fiction wise 148A clause. Please follow these directions and follow and come. In case if they say something adverse, that's a strong point wherein you can invoke a writ or something. Take a direction that this is the judgment of the Honorable Supreme Court. They are not complying. This is the interpretation part wherein you can interpret. My reading says that this including is inclusive definition. Exhaustive is all the categories are covered. Where you have filed order in your favor, you have filed matter pending, you have filed not yet listed, you have filed no writ number generated till date, or you have not filed. All categories come into this. If under an amended act, they have issued you notice effective 1st April 2021 till date, wherein they are supposed to follow the pre-notice process. Even otherwise, this line, this para is important, friends. This last para which I'm reading, this is para number 10 of the judgment, clause 2, last para. This categorically, Honorable Supreme Court categorically says no inquiry. This is not mandatory for the AO to do any inquiry if they have an information. it says even otherwise as observed here and above, holding any inquiry with a prior approval of specified authority is not mandatory. They're not supposed to have a specified authority approval before any inquiry, before they issue you 148A. It is not required. So in case if we are going to trigger something on this point, then it obviously there is a probability that the things goes against us, because the Supreme Court is categorically given that this is a discretion. It is not required to have a prior approval of specified authority. It is not mandatory. So certain things are also coming from the judgment other than the directions. But it is for the concerned AO to hold any inquiry if required. It is a discretion. Whatever, if they feel so, they can do an inquiry. No specific prior approval required from the authority. After conducting all the process, the assessing officer shall thereafter pass an order in terms of section 148A clause D. After following the due procedure as required under section 148 clause B, they are supposed to follow the due procedure. So in case if there is a flaw in the procedure, that is the flaw which is against the mandate of the law. You need to see, you have to ensure that they comply with all the process given in the mandate. 4. All the defenses which may be available to the assessee under section 149. 149 is what? 149 is a time limitation, 3 years, 10 years cases. And which may be available under the Finance Act 21 and in law. And whatever rights are available to the AO under the Finance Act are kept open and shall continue to be available. So everything under finance. So if you believe that the notices issued by the AO is time barred, you raise that voice following 149. So defenses is available. The Honorable Supreme Court says that defenses are available to you. If you believe anything is against the mandate of law, you challenge it. You write it down. At the time they give you a material and the reason, you write it down at that stage only. And if they not comply, then obviously. And if they pass a 148A clause D order, then your remedy available is you go and challenge it before in a writ petition and before jurisdictional high court. That this is the mandate of the law, they have not complied. So these were the things which is opened by the Honorable Supreme Court to both the sides, assessee as well as to the department. The present order shall substitute / modify respective judgments. Respective is the tabular judgment which is given, and orders passed by respective high courts, quashing the similar notices issued under unamended section 148 of the Act, irrespective of whether they have been assailed before this court or not. This means the Honorable Supreme Court is saying that, look, we know that the SLP was filed against Honorable Allahabad High Court judgment only. But even other 7 high courts, 6 high court was also there who have passed an order, though the SLP has not been filed, but this judgment is applicable on you. That is the reason on Pan India word they have done a bold in the judgment. What was the reasoning given by the Honorable Supreme Court? This was given in para 9 of the order. We are also of the opinion, now the reasoning behind this order, we are also of the opinion that if the aforesaid order is passed, it will strike a balance between the rights of the revenue as well as a respective assessee, as because of a bona fide belief of the officers of the revenue, bona fide belief, please read bona fide belief, because the officer was relying on that explanation. That was the reason of issuing notice under the old law, though the new law was already triggered. That was the reason of that. Because of that error, they have issued 90,000 notices. The revenue may not suffer, as ultimately it is the public exchequer which would suffer. That is the reason. Therefore, we have proposed to pass the present order with a view avoiding filing of further appeals before this court and burden this court with approximately 9,000 appeal against a similar judgment and order passed by the various high court, the particulars of some of which are referred here and above. Clearly, the Honorable Supreme Court has given that we are proposing to pass the present order and no need to file further appeal against different high courts. They have also mentioned they are also proposing to pass the aforesaid order in exercise of power under Article 142, which they have an ample power under that, by holding that the present order shall govern not only the impugned judgment, which is the SLPs, and orders passed by the High Court of Judicature at Allahabad, but shall also be made applicable in respect of similar judgment and order passed by various high court across the country, and therefore the present order shall be applicable to Pan India. Applicable on all the judgments, and it is applicable Pan India, effective from the date of pronouncement of order. Honorable Supreme Court order applicability. If we read para 11, The present order shall be applicable pan-India and all judgments and order passed by different high courts. This is important. All judgments and order passed by, wherein the final order has been passed by different high court on the issue and under which similar notices which were issued after 1st April 21 issued under section 148 of the Act are set aside and shall be governed by the present order and shall stand modified to the aforesaid extent. The present order is passed in exercise of powers under Article 142 of the Constitution of India so as to avoid any further appeals by the revenue on the very issue by challenging similar judgments and orders with a view not to burden this court with approximately 9,000 appeals. We also observe that present order shall also govern the pending writ petitions. Many of the writ petition wherein that particular High Court has not taken the position. For an example, Honorable Gujarat High Court judgment reserved. Many other benches, the matter is pending. This order is applicable on those also. Pending before various high courts in which similar notices under section 148 issued after 1st April 21 are under challenge. So these were the findings of the Honorable Supreme Court. The reason of going and understanding the para-wise judgment is to understand what was the thought where Supreme Court has analyzed pre-Finance Act 2021 of the reassessment law. They have seen the Relaxation Act. They have seen the notification. They have seen the notification. They have gone through the Honorable High Court judgments. They have seen new Finance Act 2021. They have considered those grounds which under the old law, which we take when we challenge the reassessment provisions. They have seen what was the safeguards and the checks and balances incorporated in the new law. They have considered the contention of the department that because of that notification, there was an error from the side, mistake from the side of the revenue officers in issuing 90,000 notices, huge revenue losses. So a lot of things were considered that, and many of the matter is pending. Because of this reason, the Honorable Supreme Court has pronounced this judgment and given a future way forward in the matter. The future way forward is, friends, is given in para number 8 and para number 10, which is almost similar. So what is the course of action? So as soon as this order comes, we can only do one thing. We can wait in case if we have 148 notices under the new law without complying with the pre-notice process, 5 categories. Number 1, writ filed, order passed. Number 2, writ filed, matter pending before Honorable High Court. 3, writ filed, matter not listed for hearing, writ petition not generated. Number 4, writ not filed in any, maybe in Pan India anywhere, but still whether I come into that, yes, you also, as per my understanding and the reading, if I take a conservative position, yes, you need to follow this. If AO is not complying, we need to inform the AO that the Honorable Supreme Court has given these directions which he is supposed to comply. This is about the order. And I know many of the questions is coming in the mind of everybody. How to interpret, many of the questions unanswered. We can only come to an answer based on interpreting line by line of this judgment only, because many of the questions are unanswered. A lot of confusion is there in the market. This is all about the judgment. Sumit bhai, Sachin bhai, any questions, please let me know.
Yes, sir. Yes, sir. So thank you so much, sir, for explaining in such a detailed manner about this 34-page judgment. And I think you have explained in the paragraph manner, so everybody will be able to understand it very clearly and easily. But as you mentioned that there are so many questions in the mind of the audiences, and as similar to me, it is applicable. So few queries I want to raise before you. First of all, like just take a 3 situation. 1, where the SSC has filed the writ and order is passed in the favor. Number 2, neither filed the writ nor filed any return or reply to the AO. Third, filed a return, replied to the AO, and gone and went with the proceeding, normal proceeding. So in these 3 situations, do you find any differences after this verdict, or the treatment would be same in all these 3
treatment will be same. Treatment will be same.
Okay. So sir, now the second question arises because 147, 148 matter says that the assessment should be completed within the prescribed time frame. and that is within the year in which the assessment the return is filed. So generally, since it is applicable for the year 20, in the year notice issued in 21 and the return is filed by the assessor in 21, so the last date is 22, so 31st March 22. But now what we are observing on the portal, that in most of the cases it is appearing that the last date is 31st March 2023. So whether the time limit has given by its own extension, or whether is there any other law in this regard, because we are not able to understand how a 1 year extension department has got by themselves.
But if they have issued a notice and on 1st April 2021, anyway, the last date for completing the proceeding is 31st March 23. But in case if they issue a notice by 31st March 20, because there are another set of litigation going.
Yes, sir.
Notice is issued dated 31st March, received on email on 1st April. That's a separate set of litigation going.
Right, sir.
So I can understand if the department is claiming that 31st March 22 was the date of notice, 21. So yes, the time period limitation is 31st March 22.
22.
But if it is 1st April, because many of the assessees wherein they have issued 1st April, since beginning the time limitation and the time limitation is showing 31st March 23.
Right, sir. So my question was actually related to the notice issued on or before 31st of March 2021. So now the second question, sir, because as the court has already mentioned that it will be all the notices which is issued as per the provision of section 48 will be considered as issued under section 148 capital A under clause B.
Correct.
Now the situation arises because it's given opportunity to the SSC to reply. And as mentioned by the court that within 30 days, the department will issue the notice giving the fact that on what basis your case has been shortlisted. And the SSC will get the time for next another 15 days to reply to this. Now, sir, my question is basically on section 148, where it says that based on the information, and what is information, that is already mentioned in the explanation, that what is information. But while the 148 notices were issued, that law was not there. But after amendment, that is after 31st March 2021, the information term is very important. So do we, as a SSC, do we need to see that whether the information on which the assessing officer is relying is as per the explanation given in the 148 or not?
So the information definition, you need to see what is there in the Finance Act 2021.
Yes, sir. So
and that's a very good point. But you need to raise that point also in your objection when they give you a reason and the information. When you're supposed to reply in 2 weeks' time, you need to raise this point also if you believe that they don't have any proper information.
Okay. Now, sir, come to another question that since you have also mentioned about the time limit issue of notice and the completion of. So while the time limit is there in the earlier law, 4 year, 6 year time was there. Now it is 3 year and 10 year, and the amount threshold is also there, so 50 lakh rupees. Since all the notices will be considered as notice and issued under 148 capital A clause B. So going back, whether applicability of 148 and 147 and 149 after the amendment will be applicable or not. If it is applicable, then whether the 3 year, 10 year criteria will apply or not. So I think in one of the interesting situations which is related to the financial year 12-13, that is assessment year 13-14, notice issued on 31st March 2021. So whether in this case or 1st April 2021, then what will be the situation, whether this is applicable or not?
In case of the notice was issued on 1st April, 31st March 21 is a different issue. If the notice was issued on 31st March 21, automatically the erstwhile provision is applicable, the older law. But if I'm not going into that litigation which is going wherein the notice was dated 31st March received on email on 1st April. I believe that 31st March was the date and the 31st March you have received that email. So they comply with the same provision which was there prior to Finance Act 2021, old law. But as soon as they touch 1st April 2021 or thereafter, if they issue a notice under that, procedure-wise, you need to see the new procedure 149, 3 years and 10 years. So that is the reason in para 4 of para 8 of clause 4, the Honorable Court has given a direction wherein the catchy point is there, all the defenses which may be available to the SC under section 149 are, and in law, whatever rights available is available. They don't want to comment about 13-14 or 14-15, which was a time-barred cases. That is the reason they are saying that if you believe that that's a time barred cases, you raise those objections as soon as they provide you the material and the reason when you are supposed to reply in 2 weeks time. You raise this ground. If you believe that is a time barred case, then raise that point. And the department and the AO has to give a detailed finding in the 148A clause D order about that if they demolish your argument or they accept your argument, because the AO has to see whether it is a fit case for issuing 148 or not. If you say, if you believe, in one of the cases I've seen where in the show cause notices, the AO has raised a point that you have taken a bogus sale / bogus purchase. It is one of the MNC company. Maybe they were actually selling iron to the company. I don't know about that company, whether that maybe that company has provided entry to 2 people or something, but obviously the party is genuine party dealing with international companies only. So the word which was written in that show cause is bogus sale / bogus purchase of 1.5 CR. We have given a ledger copy and said, Baba, there is no bogus purchase. We doesn't have any purchase with that company. We only have sale, and that not to that 1.5. We have done a sale of 4.5 CR. How could you have taken the figure of 1.5 CR? Though they have not considered my reply and they have passed an order under 148A clause D. So these type of things if the AO do, then yes, you have a full right to challenge it. And I believe to challenge it before the right forum, which is the jurisdictional high court, you challenge it in a writ petition. Wherever the mandate the AO is breaching, they're not complying with the mandate of the law.
Okay. Sir, coming back to the judgment and the comment given by the ASG. So this is important. I just want to input from your side also, that what is the force behind this, that the court has invoked 142 and that too in the revenue matter. So generally, as you mentioned that in the span of 72 years, you haven't seen such type of thing. So what is the force behind this, that the part that court has went into the constitutional power and applied 142?
I'll give you a detail, sir. This is coming from the order itself. This is your answer. That is the reason I have taken all the relevant paras here. Rather than me giving something, it's better to actually show what the Honorable Court has given. This is the force. We are also of the opinion that if the aforesaid order is passed, it will strike a balance between the rights of the revenue as well as the respective SSC. As because of a bona fide belief of the Office of the Revenue in issuing approximately 90,000 such notices, the revenue may not suffer, as ultimately it is a public exchequer which would suffer. Sir, if it would have been a private party case, the Honorable Supreme Court will never invoke 142. The huge, because of the bona fide reason, obviously the AO was actually relying on that explanation to the notification before issuing notices, and that was a mistake. The court is accepting that is a mistake. But because of that bona fide mistake, they have issued so much notices, and that is the reason of invoking Article 142. Complete justice. They believe that this goes against the government. This goes against the public exchequer. So they wanted to give another chance to the revenue to improve the error which they have done. And that is the reason they are saying that, look, don't consider it as 148. You consider it as 148A clause B show cause. But you need to follow these process. This is the force, sir. Now, another force is where, as soon as you mention, this is another force, is this coming from the contention of the revenue.
So, sir, coming to the similar point that ASG has mentioned in this note, that it is a historic verdict for having crafted for first of its kind on same of the legal issues, brought it firmly on the adhesive of the jurisprudence, and therefore would be discussed, debated, and remembered. So my point is, it is also, the ASG is also thinking that it is the first time the court has taken such type of view, and at the same time the Honorable Supreme Court has mentioned in the order point number 8 that it is a mistake from the department side. So when you are the lawmaker and you are doing the mistake, then how we can say that a bona fide mistake it is from your side? So you are the lawmaker, you are the thinker, and you are doing such type of mistake. Then why such type of benefit should be given to the department?
The Article 142, Sachin Bhai, is a section article which gives complete power to the Honorable Supreme Court. That if you believe that in the interest of justice, something you have to take a position, That is a power given. This was the decision. This power the Honorable Court has exercised in the time of, at the time of Ayodhya Janmabhoomi matter, Union Carbide cases, Bhopal gas tragedy case. They have taken this position. You remember there was a judgment wherein a lot of accidental cases was happening because on the highway within 500 meters there are a lot of liquor shops was there. So for banning those liquor shops, the Honorable Supreme Court has invoked that Article 142. Many of the judgment recently, if you see last, I think 7-8 years, a lot of judgments wherein the Honorable Court has invoked 142. Yes, why I'm saying in 72 years, because our constitution comes into picture from 1950. I have never seen, as per my understanding, I've never seen any of those 140 in revenue matters, wherein the revenue is involved and income tax, in the income tax jurisprudence history, 1922 Act, let us not go to 1922 because constitution comes in 1950. In 1961, till date, I have never seen any judgment wherein 142 was invoked. This is the first judgment on 142. And the reason was, why I'm coming to the reason, you see the background, you see the contention raised by the revenue, bona fide mistake by the officers. Just because of a day gap, we lost revenue, we lost all these things. Court was saying, look, I understand that under Finance Act, you have a right, not under the pre-amended law. But the error was a bona fide error by the revenue officers because they were relying on an explanation to the notification, which they are accepting that this is wrong. They are not saying that the Honorable High Court has given a wrong verdict. They're accepting that, but they're only pointing out, if you read what the Honorable Supreme Court is giving, that the Honorable High Court must have seen all those things before pronouncing a judgment. So they were giving a guidance to the High Court that why not you look all those things which we are looking and take a call. This is at page number 27 of the order. I'm reading it. Therefore, we are of the opinion that some leeway must be shown in that regard. Page number 27 of the judgment, which the High Court could have done so. Therefore, instead of quashing and setting aside the reassessment notices issued under the unamended provision of the Act, the High Court ought to have passed an order construing the notices issued under unamended Act or unamended provision of the Income Tax Act as those deemed to have been issued under Section 148A of the Income Tax Act. This was the expectation of the Supreme Court, Honorable Supreme Court from the High Court. As per the new provisions, Section 148A and the revenue ought to have been permitted to proceed further with the reassessment proceeding as per the substituted provisions of Section 147 to 151 of the Act as per the Finance Act 2021, subject to compliance of all the procedural requirements and the defenses. Defenses, the same language which they have used under 149, which may be available to the assessee under the substituted provision of Section 147 to 151, which may be available under the Finance Act. So what they have passed, they were expecting from the Honorable High Courts that instead of directly quashing and setting aside, they would have gone to that level and they could have taken the position on this ground, which the Honorable Supreme Court is taking.
Thank you, sir. We have some queries from the audience, and
Yes,
I would like to take one by one.
Yes, sir.
So, Mr. Dhananjay is asking that my client received notice under Section 148 capital A for assessment year 15-16. Is this correct as per new law? Income escaped is more than 50 lakh, but government has relaxed as per the first proviso of Section 148 capital A. So why notice? Notice received on 31st March 2022.
So 15-16, new law. If asset value is more than 50 lakh, 149 subsection 2 triggers. Obviously, there are certain criteria. So if I talk about 10 years, 15-16 is going to be on 31st March 26. Now, after 1st April 2021, 4 and 6 years concept is no more in the system. So if it is more than 50 lakh, they can issue notice till 31st March 2026, 10 years from the end of the relevant assessment year. But if it is less than 50 or 50 lakh less than that, then they only have 3. It is time barred for 3 years criteria. But if the department is invoking 10 years, it is still they have a time till 31st March 2026. But you need to see what document they have, whether they, because if they are invoking Article Section 149 new law, then there are certain criteria. This is exceptional situation which the department could only invoke. They have certain criteria. Are they complying with those criteria? You need to see. And whether the document or the asset value is more than 50 lakh, if they prove that it is more than 50 lakh, yes, they can issue.
So assuming they are satisfying the criteria, then it is okay.
Yes, sir.
Okay. Sir, C. Ashok sir has asked that, sir, whether notice for assessment year 13-14 is still valid as it cannot be issued under new Act 2021.
So assessment year 13-14, as I have already mentioned, was going to be time barred on 31st March 2020 because of TOLA extended till 30th June 2021. So I assume that you have received the notice within 30th June 2021. Correct. So if you have received this notice within 30th June 2021, during that time, this is within the provision, within the time period. Now, have you challenged it before writ petition? Now, this is important. Have you challenged before High Court or not? If yes, High Court has given you a stay initially only. If you read a judgment, all stay, I'll coming to the main point. Anything related to the stay or something is the time period which is excluded.
Okay. Sir, Udayan sir has asked that, sir, what about 50 lakh limit? So I think his question is related to this judgment that whether 50 lakh limit will be tested or not.
That has been answered, I think.
Yes, sir.
Sorry, please, Sachinji, what you're saying?
So I think this question is related to this judgment that whether 50 lakh limit is to be tested or not, considering all the notices falling under the category of 148 capital A clause B, then whether this limit is to be tested or not.
50 lakh, because they have not given a detailed finding. They are only saying that all the defenses available, because the Honorable Supreme Court, why they have given a specific finding in all the parts. But if you see, they have not given a detailed finding in 149. Very clear in all the points. Only thing which they have mentioned is all the defenses which may be available to the assessee under section 149 and which may be available under Finance Act, and whatever right shall continue to be available. So this is still open. So if you believe that your case is time barred, you can raise that point, which the Honorable Supreme Court is also saying, because it is not a clear direction. It is an open-ended direction. Whatever defenses you have, it is available to you. And 50 lakh, more than 50 lakh, this comes under 149 criteria.
Yes, sir.
So, but one thing, sir, if you believe that your case is not falling into that, once you receive the information by 2nd June, please file your reply within 2 weeks. 2 weeks is sensitive. We need to comply with the Honorable Supreme Court direction. Otherwise, our department will never give us another chance. And that's a strong point that why you have not complied with the Supreme Court direction.
Right, sir.
Not 2nd June, whenever you received that details from that date, you have 14 days time. So if you believe that the 50 lakh period is there, they don't have anything, any information more than 50 lakh, you have all the documents with you, or maybe in your case, the original assessment has already been done, please take this thing in your reply. And if they not consider and pass an order, challenge those orders.
So Naveen sir has asked that what about the 13, 14, 14, 15 notices, whether it is valid or not?
Have they filed a writ petition?
No, but only this question is there.
This fact is not mentioned. So assuming they have not filed.
No problem. Now I assume that the notices was already issued within time. 1st April to 30th June. So based on the TOLA, that this was the time period which was extended. So these 13, 14, 14, 15 was challenged before various High Court in a writ petition on a legal ground only. Pre-notice and the notification, explanation to that notification only. So after the Supreme Court judgment, on a conservative side, if I say, all those notices, the court is saying if they have issued a notice, you convert it into that 148A clause B. So I personally, what my understanding on a conservative approach of reading this judgment, because if I take a different position, that would be more aggressive position. So on a conservative approach, I believe yes, because the notices has already been issued by 30th June. What the court is saying, you deemed that 148 as 148A clause B. Now, what is important? Let us see what reasons and the information they have. So I personally believe if they have issued a notice, that notice is active based on the judgment's understanding. I don't know about the background, whether you have challenge in a writ petition or not. I simply believe you have received the notice. Conservative approach says, yes, they are replacing that notice with 148A clause B. You consider it as 148A clause B notice. And let us wait and see what information material they are relying.
Okay, sir, another question what we have received, notice was issued on 31st March 2021 as per portal and mailed after 31st March, and now order got passed.
Order got passed. Which jurisdiction, sir? Allahabad High Court has already given a decision in favor of petitioner. Madras High Court has given against the petitioner, and matter pending before Honorable Delhi High Court, a batch.
Right.
So now we have one favorable judgment, one against unfavorable judgment, and the matter is pending before the. You need to see which jurisdiction. I have you now. My point is, I consider that the case comes into Delhi High Court jurisdiction because many of the audience is from Delhi High Court jurisdiction only. So I personally believe if the order has been passed and whether you have raised that point before the AO or not, if raised, have you taken those grounds in an objection? If you have taken, whether the AO has passed an objection disposal order against the same or not. If not, then please, though they have passed order, you can challenge it before jurisdictional Delhi High Court in a writ petition, considering the AO has not given a reply to your this query. Because once an order has been passed, so High Court has a very limited area wherein they can interfere, because obviously it's you always have an alternative remedy available. So either you challenge it on 144B ground, or yes, this is also very strong ground. But you need to see whether you have taken this ground before you or not. But please, before challenging something, please read Madras High Court also, which is against.
Yes, sir. Yes, sir. Thank you, sir. So another question: if 10-year limit is triggered, then condition of income more than 50 lakh in the form of asset is also required to be fulfilled. So I think it is asking about the 3-year and 10-year time limit and the threshold of 50 lakh.
Yes, threshold of 50 lakh is a relevant question, because 50 lakh decides whether you come into 3 years or a 10-year parameter.
Right.
If AO is saying that you have a bogus purchase of 1.5 CR, but you have a strong proof that it is not a bogus purchase, then yes, you can always take that position. That legal argument, you can take it.
Thank you, sir.
And more stronger case comes wherein your original assessment has already been done. That would be more stronger case in those situations. 143.1 to 148, yes, it's on a little complicated part, but if it is 143.3 after 148, then yes, you can take these grounds also. That they have already gone through all the papers. Now they are coming in with some separate fresh information.
Thank you, sir. So another question from Sunil, sir. What about the fate of return filed in response to notices under section 148 issued after 1st April 2021?
No problem, sir. That's just a compliance. The majority of the people have just filed the original return as 148. So there is no problem. Based on this direction, I believe it is to be treated as null and void. They'll issue you details, and if they are satisfied, they issue you again 148 under because that return was filed under 148, which was issued under new law, but followed the old law. So as per the direction, I don't think if 148 gone, if they are converting that 148 into 148 clause B, then there is no relevancy of that return filing also, sir. This is my conservative view. I'm again saying, as a lawyer, I'm always aggressive in certain things. But if you wanted to file a case, otherwise it is always better you read from a compliance perspective. Please read the judgment in a more conservative manner.
Right, sir. So Ranganathan sir is asking another question. Is there any exclusion of the date of receipt of email in calculating 30 days? So he is asking about the court verdict of 30 days limit.
The court categorically says 30 days from today. Today means the date of pronouncement, which is 4th May. Please compute 30 days, 28 in the month of May, and then 2. That is 2nd June. That is the reason I have given the time period 2nd June 2022, the last date. Count it from 4th May, from today. 4th May till 2nd June is 30 days. So last day is 2nd June, the department. And if AO is not giving you a reason within 2nd June, it's a good case for you to challenge in a high court that they have not complied with Honorable Supreme Court judgment. because this direction is a very tight jacket direction. This, especially the time period is a very tight jacket. It's a clear-cut direction, 30 days and 2 weeks. Whether the department misses the ball or you misses the ball, then it will be in a difficult situation.
So Sudesh sir is asking, can we raise objection memorandum post 148 capital A clause D order in the new regime?
So that now this is very important, sir. Honorable Supreme Court, what they have analyzed, what I believe is, what they are saying is that GK and drive-shot judgment is applicable on the Pre-Finance Act regime only.
Yes.
Now there is no provision of, so what my understanding in the reading is, objection disposal order is nothing. Passing an order under 148A clause D along with 148 notice is an objection disposal order now, because GK and drive-shot judgment checks and balances is now incorporated in the statute. So the objection in the earlier regime, the objection was nothing. As soon as the court has given you 2 weeks time to file reply, that reply is nothing. That is actually an objection which you have to raise.
Okay.
If you see, sir, 148A clause D is not an appealable order under 246A. So that is the reason. If you believe that there is a statutory flaws in the mandate, the AO is not complying, then it is always better you based on the discussion with some counsel or something, you always prefer filing and challenging it before jurisdictional high court in a writ. If they have not, if they are not complying with this statutory mandate of the new regime.
Thank you, sir. Sir, we will take another 1 or 2 queries.
Please,
There are a long list of queries, but due to
no problem, Sachin ji, no problem. Please go ahead. I would love to address all the queries.
Yes, sir. We know that this topic is very close to your heart, and you are enjoying. Basically, you are enjoying replying to such type of queries. So, sir, Sanjeev,
I'm also learning from my friends, sir. Many of the issues they are actually facing. I'm also applying my brain how to apply that law into that facts.
Thank you, sir. So, Sanjeev sir is asking, ITR against notice received for the assessment year 15-16 after April 2021 has been filed, and reason to believe is still awaited, and not aware whether it falls under the category of more than 50 lakh or not. What will be the impact of latest Supreme Court decision in that case?
The assessment year 15-16, 148 notices, when it was issued?
After April, so notice return filed after April. So assuming notice issued within 31st March.
Within that 3 months quarter,
yes,
1st April 2021 to 30th June.
Yes.
As soon as you have received a notice, so I believe you have filed a return. Now the time comes, sir. They are supposed to give you a reply, this information material. So they'll give you material by 2nd June now.
Okay.
Now they'll give you a material. They have to follow that.
Sir, Rahul sir is asking, as per section 149, how to consider threshold limit, that is 50 lakhs. So whether counted all assessment year, aggregating 10 year, or single assessment year?
Single assessment year, sir. Every assessment year is a different assessment year.
Assessment year.
Income tax works on a assessment year wise, sir.
Yes.
Every year is a different year.
So Ranganathan sir is again asking a question: is this judgment not a bench judgment? If yes, whether it can be appealed before bench? So it is talking about larger bench, I think.
Good question. I'm just, whatever I'm saying is my understanding. Maybe people have a different view also, but as per my understanding about the law, if you read, I'm just telling you the relevant para. I believe this is a consent order. So even I have a doubt about whether anybody can file a review petition or not, because I believe this is a consent order. Once it is a consent order, you cannot challenge it in review petition also. I'm telling you the relevant para, sir. This is a very good question. Para number 9. I'm reading. There is a broad consensus on the aforesaid aspects. After giving the direction, Honorable Supreme Court in para number 9 has mentioned there is a broad consensus on the aforesaid aspects amongst the learned ASG appearing on behalf of the revenue and the learned senior advocates / learned counsel appearing on behalf of the respective SSE. We are also of the opinion that if the aforesaid order is passed, it will strike a balance between the rights of the revenue as well as respective SSE, as because of a bona fide belief of the officers of the revenue in issuing approximately 90,000 such notices, the revenue may not suffer, as ultimately it is a public exchequer which would suffer. So consensus means consent order, and once it is consent order, there is no scope of review petition. But this is, I think, by the legal stalwarts must have a different view, who has a better understanding about the constitutional law. But as per my understanding, this is a consent order. I think there is no scope of review petition if we read para number 9.
Thank you, sir. So I think we have covered all the queries now.
C.M Jain Saab is there.
Yes, sir.
C.M Jain, you want to ask something? And I think Divyanshu ji very well covered all the point and wonderfully addressed the Supreme Court judgment.
Thank you so much, Sachin bhai. Thank you so much, Sumit bhai. And I would love if somebody have any other questions.
Any other member you
there are
want
a lot of controversies, there are a lot of questions, Sumit bhai, Sachin bhai, there are a lot of questions going in the market, a lot of messages, a lot of discussions. I understand, a lot of confusion is there. But sir, what is important is to understand the facts. If you are saying a notice, whether you have filed a writ petition or not, the matter was stayed or not, a lot of things you need to see before coming to an answer. So,
Right, sir.
But it is equally important to understand the intention, because my reading of the judgment is to understand the intention. What was on a larger side, why the court was thought of invoking this article, what was the logic, and everything is coming from the judgment itself. 90,000 notices, bona fide mistake. Sachinji, if I would have been into that situation, 90,000 notices is a big revenue loss for the government.
Yes, sir. Agreed, sir.
Right.
That's a big revenue loss. And I think these type of issues never came before in the income tax matters before Supreme Court, such a big matter. A minor mistake and huge losses to the revenue. Might be this is one of the reasons that the Supreme Court thought of invoking Article 142 in this case.
Yes, sir. Yes.
And this is one of the exceptional situation. I think we have never seen these type of situations in the last, I think, 7 decades.
And that's why they have taken this decision first time, because huge revenue amount is involved.
Huge revenue. And they have tried to come with a win-win situation. That is the reason the consensus would. And fortunately, I was there before the court. One of the matter I was also handling. So I've seen what was the discussion going, 90,000 notices. It's a big amount. I think 1 lakh crore or something amount is there. So it's a big amount, and that's a big amount. Considering the situation where the government is going, they need funds. So I think 90,000 notices, I must say 10,000 or maybe 20,000 in case if they find 20,000 notices wherein they hit the bullseye. That is a sufficient ground wherein they can generate a good amount of revenue.
Right, sir.
Yeah.
And at the same time, this is a win-win situation for all the practicing professionals also, because they will also get the opportunity to handle such type of cases.
But Sachinji again, Sumitji again, it's a tight jacket direction. We miss the bus or the AO miss the bus. That's a strong ground of litigation. 30 days is 30 days. But in case, if take an example, Sachin bhai, if you receive in your client case the reasons tomorrow is what? Tomorrow is 6th of May. And maybe you are traveling with your family outside somewhere, school or holidays coming. Now 14 days is a very tight jacket. As soon as you receive within 14 days, you have to file your objection, otherwise you lose the benefit.
Right, sir.
We need to be very sure that these timeline is we need to comply. And even if AO is not complying, then that be ready for filing a writ in case if they're taking a different position.
Sir, Dhananjay ji पूछ रहे हैं कि why in judgment it was said unamended act.
No, unamended means they have issued a notices under unamended provision based on relying on that explanation to that notification that this old law is still going.
Right.
But ideally they are supposed to issue a 148A prior to issue 148. They have not complied that. That is the reason this unamended bona fide mistake, these words are coming in the Honorable Supreme Court judgment. Sachin bhai, Sumit bhai, other than consultants or the lawyer, the professional, if we see a larger picture, so 90,000 notices is a big notice.
Yes, sir. Yes, sir. Agreed, sir.
Big number. Sir, last query एक ले लेते हैं नारायण
sir, ले लीजिए, please.
Narayan sir is asking, asset referred in section for 50 lakhs limit is assets
Sir, assets की तो inclusive definition है act में.
31st March. Okay.
क्या नहीं, मैं query क्या थी? Can you please repeat that query, Sumit bhai?
Last में if you can see.
अच्छा, I'll just open that chat box. हाँ.
So एसेट में सर कैश आता है क्या?
सर बैंक आता है तो कैश भी आता है सर।
राइट सर।
इंक्लूसिव में बैंक है तो अब मतलब अगर मैं बात करूं तो मेरे ख्याल से पेटीएम यूपीआई सब आता है सर आज की डेट में।
कैश
बैंक इट्स बैंक मींस कैश आल्सो कम्स सर, अकाउंटेड कैश।
सर ये नारायण साहब ये कुछ लिखना चाह रहे हैं, मैंने क्वेरी पोस्ट की है।
हाँ,
यू कैन सी
asset referred in section for 50 lakh limit is asset subsisting on 31st March. Yes, I'm just trying to figure out where it is written in the act. अच्छा, एक point I just wanted to inform everybody. 149 में third proviso is very relevant to decide. Sumit ji, Sachin ji, third proviso for everybody. Third proviso, please read. Third proviso says, provided also that for the purpose of computing the period of limitation, as per this section, the time or extended time allowed to the SC as per show cause notice issued under clause B of section 148A, or the period during which the proceeding under section 148 is stayed by an order or injunction of any court shall be excluded. So आपका जो facts है कि हम आएंगे या नहीं आएंगे, उसके लिए आपको you need to see your case facts, and based on that you can take a position कि हम आएंगे या नहीं आएंगे. Explanation: for the purpose of this clause B of this subsection, assets shall include immovable property, being land or building or both, shares and securities, loans and advances, deposits in bank account. Sir, अभी जो notices आ रहे हैं ना, notices में even if you are not filed your return and the cash deposit is more than 1 crore or 50 lakh, they are including that also in the notices. 148A clause B show cause. You're taking this position कि agricultural land sale है, हमने उसका cash deposit किया, but that also it is coming.
Because that is a deposit in the bank account actually. So based on that, then they have to, then you have to explain that what are the sources, how you are from, where you are, what are the nature and sources.
And the problem comes wherein you have not filed your original return.
Yes.
Because many of them people, they have met me and said that we wanted to file writ, but they have not filed the original return. So I have categorically informed them, please do not go in a writ if you have not complied with the law. So I'll reply, Sumit ji, I'll reply this question. आप मुझे ना, मैं just copying it down. I'll reply to this query.
Okay. And Naveen ji want to ask something. Naveen ji, can you unmute yourself?
Yeah. Yes, sir. Am I audible, sir?
Yes, sir.
Sir, thank you, sir. It's an excellent session, sir. Very beautifully explained. Sir, I am calling from Bangalore now.
Okay.
I have got 2 questions, sir.
Yes,
One
sir.
is, if you see at the page number 32 of the order, sir. Page
Just
number
a minute,
32 of the order. Yeah. At
Page
point number
32.
2.
Yes,
Yes,
sir.
sir. Yes, sir. Page number 32 at point number 2.
Yes, sir. Clause 2. Yes,
Yeah,
sir.
if you come to 1, 2, 3, 4, 5, 6th line, it says under section 148 of the unamended act from 1st April 2021 till date, including those which have been quashed by high courts. That means it's not only from your 1st April to 30th of June 21, the Supreme Court is telling all the notices issued from 1st April 21 till date.
Yes, sir. And your defenses under 149 is available. If they have issued a notice, which is time barred under 13, 14, 14, 15, then your defense under 149 is available.
Okay.
So 13, 14, 14, 15, if original notice was issued between till 30th June 2021.
Yes, sir.
Under TOLA, the time was extended. So
Correct.
that was not time barred.
Okay.
They can replace that 148 with 148A clause B notice. You cannot take that pleading of time barred ground there. But yes, if your AO has issued 13, 14 notice under 148 on 2nd July 2021, that's a time barred case.
Correct, sir. So 13,
Yes,
14, 14, 15 up to 30th June 21. And also you can see the meaning of asset and more than 50 lakhs because I have
Correct,
to apply
sir.
the new regime.
Correct, sir.
Fine, sir. I agree with your reasoning, sir, because just today, if I can see, there are 3, 4, articles in the Taxman software where the Taxman, if you see 3, 4 articles are there, where they are clearly telling that 13, 14, 14, 15 cannot be reopened, which I don't agree with the learned speakers. And I am agreeing with you because department will not keep quiet. Because out of 90,000 notices, as you rightly pointed out, maybe 40-50,000 notices are for 13, 14, 14, 15 itself.
Majority of the notices you
Yes,
can,
sir.
You can throw a better light what was happening there in Karnataka, Andhra Pradesh, other places.
Yeah.
Maximum of the cases they have issued notices till 30th June. So
Correct,
major
correct.
litigation which is going is between 1st April to 30th June. So now what is the, I read it like this. What I read it, they are replacing your 148 notice. The date was original with 148A clause B. So if your 148 was raised or issued on 30th June, which is time limitation under TOLA, then they can replace. But if your original, like if your original notice was wrong, time barred, then this also become time barred. So this is my reading, sir. If they issued on 1st July, yes, that is time barred case. But on 30th June, no, it is not time barred.
Yes, sir. To add to this last 1 minute, what
Yes,
about
sir.
the orders already passed, sir? Orders already passed under 147 now. Now, the department in few cases, I'm not telling all the cases.
And I
because as
agree.
we told
Very
that-
good question, sir. Very good. Mind-provoking question. Very interesting question, sir. Orders has already been passed. Now what happened?
Correct.
Please, and our question is whether you have filed an appeal or not. You write it down. Please write it down to an assessing officer attaching the Supreme Court judgment, saying that look, as per my understanding, now this order has been changed, and if you have challenged that thing, I believe the order has been passed because you have not filed your writ petition. Correct?
Correct, correct.
Sir, Karnataka High Court, the matter is still pending. Your jurisdiction.
No. But, sir, Karnataka High Court, it is passed. Mohammad Mustafa's case. It is
Achha, it has been passed. When it has been passed, sir?
Yes, sir. Yes, sir.
So I think these facts were not before Supreme Court, otherwise they would have included that Karnataka also. But anyway, in a broader sense, it is covered. So your case, why they have passed in order? Have you not filed a writ petition in this situation?
No, sir. Writ petition is not filed.
Have
Only
you raised
CIT
this
appeals.
ground?
CIT appeals.
No. Okay, it's okay. But have you raised this grounds of the different high courts in your petition?
No, sir.
That's the reason, sir.
Yeah.
So you can take a chance. I'll suggest you take a chance. You write a letter to AO attaching the Supreme Court judgment saying, and write a letter to the PCIT, write a letter to PCCIT, and write a letter to CBDT also.
Fine, sir.
For a better clarification. What is the understanding? Because then in that situation, I believe probably they'll take an opinion from a learned Attorney General's office also. How we read it. Because they are the best. But please write it down to these officers. Right?
Fine,
And CC. And even if you're writing to AO, please mark CC to PCIT, CC to PCCIT, and CC to CBDT.
Fine. Thank you, sir. Thank you very much.
And if you get any reply, probably they are not going to give you reply. But if you get any reply, so they, because of you, Naveen sir, because of you, I think probably many of the CS will handle that thing very easily. Somebody has to take a position.
Yes, sir. Thank you, sir. Thank you very much.
And then we'll read your name in a newspaper.
Thank you.
Thank you, Naveen ji. Now,
Thank you so much.
CM Jain want to ask. CM Jain, are you there?
Jain sir, bataiye. Yes, sir.
He has posted one query in the chat box. I think his mic is not working. New notices
No
under
problem.
section 148. Jain sir, are you there?
New notice under section 148 for the assessment if 1516 has been issued on 31st March 22. Sir, not 148. I believe they have given you 148A clause B notice first. Then have you responded? You have responded. What was the reason they have
Jain
given
sir,
that?
unmute hello, please.
Sir, what was the reason you have you filed your reply against the show cause notice? Please write it down, sir.
I think the problem is there.
I am doing a lot of writ. I am writing writ only.
I think some connection have lost. So very well.
Sumit ji, anybody has any query, I would love to address all the queries. You can send me on an email also.
I know, Divyanshu ji, you are very competent in this matter. If any issue is left, you are always ready to answer.
And I have learned something new. Naveen ji has given me new information that Karnataka. Naveen ji, I would request, please write down the name of the judgment, please. I am like not aware about Karnataka High Court verdict.
I think
This way we learn actually.
उन्होंने लिखा है, just a minute.
हाँ, एक जजमेंट बताया था उन्होंने कर्नाटका का।
हाँ, नवीन जी ने सर जजमेंट अर्लियर नहीं।
Some
अगर
Mustafa
नवीन जी
judgment he
available
is
हो तो
telling
kindly
me.
write the case in the chat box. Asa ji, do you want to ask anything? Mustafa, some judgment? No. So I think सभी लोगों की query well addressed. Many members have joined from one is from Jammu.
Sir, if the High Court and Supreme Court can take up the matter once the question law involved in that case, why Supreme Court can say this is a bona fide intention, this is only procedural irregularity? So we have already given the reason behind it.
Right, sir.
Thank you so much, sir. Well covered. Now over to Sumit ji.
Thank you.
Thank you.
Sachin ji. First of all, thank you very much, Divyanshu ji, for your wonderful deliberation in the very short of span of time. Yesterday night, we have talked with the Divyanshu ji to plan a webinar tomorrow for today. So he has ready the material and information to address the audience at large. Thanks to Sachin ji, Asha ji, Raman Gupta from Chandigarh, C.M Jain, and entire members from the entire region who have joined to make this interactive and successful webinar. अजीत पटेल जी वाराणसी से जुड़े हुए हैं. अभी दिव्यांशु जी ने कहा था कि फ्रॉम स्पेशली फ्रॉम दिल्ली. दिव्यांशु जी आधे से ज्यादा मेंबर दिल्ली से नहीं होंगे, आधे मेंबर्स एंटायर. अभी नवीन जी बेंगलोर से थे, नीरज नागपाल जी जम्मू से जुड़े हुए हैं, अशोक गर्ग जी फ्रॉम संगरूर, पटियाला.
Very good, sir. Sir, Punjab and Haryana order was saying, I was there also. Punjab and Haryana says matter was adjourned Senate on 22nd February 2022, and for the outcome of Supreme Court. They have not passed an order, but as we have already mentioned that the pending rate. So now this Punjab and Haryana High Court is also covered into this.
Right, sir.
Varanasi comes into Allahabad High Court covered. वो judgment ही Allahabad High Court का था जिसमें selfie file हुई थी. Naveen sir, Bangalore High Court, Karnataka High Court already passed, covered. Jammu and Kashmir High Court, anyway, now it is the Supreme Court has given that this judgment has its impact on pan India. So it has an impact everywhere.
Everywhere. So once again, thank you very much, Divyanshu ji, and all the participants who have joined and make this program successful. Thank you very much. Thank you.
Thank you, sir. Thank you.
Thank you so much. And my apology, I don't know what happened to the video today. I was sitting with tie and coat on, and my video is not working.
Face today. Thank you.
Thank you so much.
Thank you. Thank you.
Thank you.